It all. Myself, Professor T.N. Divakar, working as the Assistant Professor in Department of Electronics and Telecommunication Engineering in Sharad Institute of Technology, College of Engineering, Itsakanji. So today we are going to see different articles for the different topics, different Constitution of India. In that, the first one is welfare and empowerment of women and legal provisions. So what are the fundamental rights? So there are different articles as I showed you. So in article number 14, it is saying that equal rights and opportunities for men and women in the political, economic and social spheres. So article number 14, it is for equality for the men's and women's in all regions, and there are equal opportunities and rights for men and women in a political, economical and social space also. In article number 15, it is for prohibition of discriminations on the grounds of sex, religions, caste. Means there is no partialities for men and women in concern of sex, religions, caste. Everyone should be equally treated. Article number 15, it says that empowers the state to take affirmative measures for women. In this case, the women have empowerments to the state levels. Article number 16, it provides for equality of opportunities in the matter of public appointments. Means wherever there is a jobs, appointments, we should have to treat equal opportunities. What are the directive principles? Article number 39, article number 42, article number 51V of AE, it states that directive principles. Article number 39 enjoins the state to provide an adequate means of livelihood to men and women and equal pay for equal work. Means for men and women there should not be different pay for their work. We should have to pay equally for the men and women according to their works. Article number 42, it states to ensure the provisions for just and human condition of work and maternity relief. For example, the women's during the delivery, those are working, they will get the maternity leaves with the pay. That is the maternity relief, as well as all humans get relief next one. Article number 51, fundamental duties on every citizens to re-announce the practices degrading to the dignity of the women. This is the fundamental duty. Financial accountability. Article number 151 reports relating to the accounts of the union and states to be prepared and placed before the parliaments and state legislative respectively. Next, the Equal Remuneration Act 197, equal opportunities, equal treatment and equal wages. See, this is the graph showing the appointments, opportunities, treatments and equal wages. So in the first, appointment of authorities not below the rank of decide label office to hear and complaints. In the second part, advisory committees notice for the establishment for the increasing the employment of the women. And in the appointment, inspectors to conduct the investigations and ensure compliances with the acts. Next one, the Maternity Relief Act 1961. The National Insurance Maternity Benefit is paid to insured the women who are away from work as a result of pregnancy. The benefit is comprised of a weekly payment of maternity allowances to a maximum of 14 weeks paid in a lump sum. Next one, maternity leave benefits should be availed by the eligibility female workers either before or after the actual period of delivery in a continuous and uninterrupted manner. Maternity leave can be used as a combination of prenatal and postnatal leaves, provided that postnatal care shall not be less than 60 days. Next one is the women specific provisions in the labor laws. The Factories Acts, that is 1948, section number 34 provides that the state government can lay down rules prescribing weights that may be carried by men and women's. The Contract Labors, that is the Abolition and Regulations Act and rules, separate provisions of utilities for women's and fixed working hours. So there is a particular hours for the women's, and these laws have a proper implementation mechanism. There is no provision for monitoring the effect of these laws on the women's, and also the allowances for specific provisions for the women's have often proven to be disadvantageous to their employment opportunities. Next one, what is the participation in decision making process? Presentation and reservations on decision making bodies. 73rd and 74th amendment to the constitution providing for reservation of seats for women in panchayat and municipalities. So we know that in all panchayat and municipalities women are also working because of this act, amendment 73 and 74, because it has compulsory reservation for the women's seat. Next one, access to legal services. The Legal Services Authority Acts 1987 title here. So national legal services involved in policy making and making recommendation, creating legal literacy and awareness. So Legal Service Authority functions providing legal services, conducting legal aid programs, and it has a authority of district level. So what are the family laws? So laws relating to the marriage, laws relating to the divorce, laws relating to the inheritance governed by laws of specific community, and the test of the validity of these laws to be made on the touchstone of article number 13 of the constitutions. So what it is saying, a number of positive amendments have been brought in the last years For example, removal of upper limit on section 125, that is a place of filing divorce proceeding. Women's right to stay in parental as well as a matrimonial home as per Domestic Violence Act 2005, etc. But a lot remains to be done, especially amendment to section number 6 of the Guardians and Wards Acts. They recognizing the equal rights of the mothers to be appointed as guardians. Next one is the what are the prohibitions of Child Marriage Act. This act is on 2006. So marriageable age for the grooms to be 21 years old. She must have a 21 years old. And marriageable age for the breach to be 18 years old. Next one, a groom, his parents, relatives and priests involved in a marriage with a minor girl to get 2 years imprisonment and 1 lakh of fine. Section number 13 of A prohibit mass child marriages on a certain days such as Akshaya Tritiya and states that district magistrate shall be deemed to be the child marriage prohibition officer. What are the domestic violence? So criminal laws section number 498A. So it says that protection of women from the Domestic Violence Act in 2005 recognize of the right to residence and provisions for the appointment of protection officers and the recognition of the service providers, training for protection officers and judges, awareness creations, budgetary allocations. Next one is sexual violence, sexual harassment. It is very important. The urgent need for legislation on sexual harassment and the institution of mechanism to address instances of sexual harassment and training of functionaries appointed. Next, rape laws. It is need for the change in rape laws, especially with the regards to recording of evidences and the provision of effective justice, so that victims are encouraged to report such offences. So need for the laws to deals with the child sexual abuse. Next one is legal awareness about the violence against the voice against the women. We must know that in India the following legal provisions are made to tackle the voice against the women. So Dowry Prohibition Act 1961, Indecent Representation of Women's 1986, that is the Prohibition Act to take action against the sexist portrayal of women in the audio, visual, print and electronic media, pornography and cyber porn. Next one is a prevention of immoral traffic in women and children, that is in 1987 to crack down on the prostitutions. Next one is a Commission on Sati Prevention Act in 1987 to fight widow burning and its glorification, and the Supreme Court directives against the sexual harassment at workplace in 1997. The prenatal diagnostic techniques, that is the regulation and prevention of misuse. The Amendment Act 2002 to stop the sexual selections at conception stage as well as of unborn fetus. Domestic Violence Act comes on 2005. So these are the following provisions are made to tackle against the voice of women. This is the Indian Penal Code. According to the images, we know that so what exactly the Indian Penal Code? The IPC section nature of offense. The IPC 304B, it is a dowry deed and murder. IPC 354, it is a criminal assault of women to outrage women's modesty. IPC 366, kidnap, abductions and marriage of women by force. IPC 366A, procurement of minor girls. IPC 366B, it imports of girls from the foreign countries. IPC 367, it is for the rape case. IPC 367A, intercourse by man with his wife during the judicial separations. IPC 376B, intercourse by public servant with women in his custody. IPC 367C, intercourse by superintendent of jail, remand home with woman in his custody. IPC 367D, intercourse by any member of management or staff of hospital with any woman in that hospital. IPC 498A, husband or in-laws subjecting a woman to cruelty. And IPC 509, word, gesture or acts attended to insult the modesty of women. So these are the Indian Penal Code. That is the according to that IPC Indian Penal Code, the different punishments or penalty has been given according to that different criminal nature of offense. Next one is the Immoral Traffic Preventions, that is Amendment Bill 2006. Decriminalizes prostituted women, penalizes buyers of prostituted women. Critique of Sita, that is the suppression of immoral traffic act in women and girls, and PETA means Immoral Traffic Prevention Act. So what are the implementation of the laws? Appointments and empowerment of statutory authorities at the central and state levels. Next one is the preparation of policy statements by such statutory authority, enclosing clear guidelines on the manner of implementation of laws such as code of conduct to be followed by functionaries, provision of best practices, etc. Next one is evaluation and auditing the effectiveness of particular laws and the periodic publications and submission of compliance reports with the central statutory authority. Next, implementation upgrading the equality of statistics maintained on women. Each statutory bodies to conduct early survey in their particular field. Sustained interactions between the different governments agencies to promote the multi-agency working. Next one is the allocation of adequate budget for the proper functioning of statutory budgets or authorities. Next, constant monitoring and auditing of accounts by the central authority, and submission of financial reports to the Auditor General for it to be placed before on the floor of the Parliament or state legislations as the case may be. Thank you.